and thank you for joining us for today's session, where we'll be looking at preparation for completion. My name is Stephen Smith, and I'm delighted to be joined as always by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Morning, Stephen.
Morning. Before I hand over to Ian, just very quickly, I'd like to go through a few items so you know how to participate in today's event. You're listening in using your computer speaker system by default. If you would prefer to join over the phone, you can just select the telephone option in your audio pane and the dial-in information will be displayed. It is a toll-free telephone, so no cost will be passed there. You will have the opportunity to submit text questions to Ian by typing your questions into the questions pane of the control panel. We will have a Q&A as per usual at the end of today's session, but please do send questions in at any time if it's on your mind to do so. You can also raise your hand during the presentation if you are having any difficulties with the sound or other technical issues. We will be able to speak to you over the chat box feature and hopefully resolve any issues there. Finally, we've also included the notes for today's session in the handout section of your control panel. If you are having issues accessing the notes, then please let me know through the chat or Q&A section, or do send me an email and I will get these sent over to you before the presentation is underway. Anyway, without further ado, I'll now pass on to Ian for the main part of today's presentation. Thanks, Ian.
Thanks, Stephen. Thank you, everyone, and good morning, and thanks for joining us again. I'm delighted to see that the numbers for today's presentation are very impressive indeed. That's, again, an amazing result, courtesy of all the work that Stewart Title are doing for the legal profession. What we're going to be doing this morning is just having a look at some pre-completion issues. To be honest with you, there's so much to cover that what I've done is just cherry pick one or two topics that I'd like to share with you, and that hopefully we can sort of add a little bit of knowledge in certain areas that perhaps you're not familiar with, or refresh some of your knowledge with regard to other areas. So quite a lot of things to talk about. As Stephen mentioned, there is a chat facility for questions. We are recording today, and you're more than welcome to send Stephen, Robert, or myself questions via email, and we'll endeavour to assist with regard to a response with regard to any questions that we do receive. So hopefully you can hear me, hopefully you can see me. I'm going to turn my camera off just to make sure that we get a better reception with regard to the audio, and hopefully you can see the slides. And what we're going to be doing today is talking about issues relating to completion, preparing for completion. And the conveyancing process, to be honest with you, as a starting point, requires time to prepare, time to think, and time, of course, is the commodity that most of us have least of. So what I'll be doing is looking at this from quite a defensive perspective to say, what can we do to get the deal done, get the job done, keep clients happy, and at the same time protect ourselves and protect our firms. So I make no apologies for being quite defensive with regard to some of the points and some of the issues that I'll be exploring and identifying. So the first thing I want to talk about is just some general issues having exchanged contracts and preparing completion for clients. And the first point, again, is my common mantra, this idea about setting realistic client expectation, making sure that clients understand their duties and obligations relating to completion. And again, and I've mentioned this before in the presentation, making sure clients are aware of the fact that although completion has been contractually agreed, there may be issues that mean completion is not in fact fixed for that date. There could be issues or problems that can arise. Hopefully, as a consequence of what we're going to be talking about today, those problems will be alleviated, or those problems may not arise, or we can plan for them and prepare for what we do in the event of problems occurring. First point I mentioned on slide here is, of course, the common law position where we've exchanged contracts but haven't fixed a date for completion. You might think that's absolutely ludicrous and nonsense and it can never happen. It has happened. What more commonly happens, however, is where a completion date is not fixed to a specific date, but is calculated by reference to another date. So an expiry of a notice, a right of first refusal, for example, to a sitting tenant or sitting tenant, this sort of thing. The important point is when we're preparing to make sure that we're comfortable, that we know precisely what the date for completion is. If we are going to reference a completion date by reference to another date, make sure that the contract is quite clear and that we're quite clear as to what the date is. and always have some form of backstop date. Remember, of course, standard condition 611, we've got a fixed completion taking place on the 20th working day after the date of the contract, where a completion date isn't agreed at the point of exchange. And remember, if we don't specify the latest time for completion, then the latest time for completion would be midnight on the date set or agreed for completion. I mentioned this third point on the slide because I think it's important. Remember, the Conveyancing Protocol requires transparency and communication with regard to problems and issues associated with preparation of completion or completion itself, but do be aware of the need for client confidentiality. I had a matter sent to me last week where a conveyancer, in the heat of battle, as it were, was getting emails from the client and immediately forwarding them on to the other side to try and explain the position, to try and make sure the other side understood what the difficulties were and where the conveyancer was encountering some problems. But of course, the problem with that is you've got to have client's authority to provide those emails. So you're perfectly. I've had an issue. Sorry about that. I think I had an issue with regard to microphone. I've just reinstated it. I'll just go back to this idea about transparency and communication if I can. The important point here is that the Conveyancing Protocol requires transparency and communication, but remember the issue of client confidentiality. You cannot, when you're preparing for completion, if there's a problem or an issue, simply ping across to the other side an email you've had from the client without client's express authority for that disclosure. So whilst the protocol requirement promotes this idea of cooperation in the conveyancing process, pre-exchange, post-exchange, on the day of completion, client confidentiality is an important point. I had an issue last week where someone sent me an email, and what had happened in the heat of battle, they'd been pinging across emails from their client explaining the position, trying to be helpful, to be honest with you. But in doing so, it breached client confidentiality. If you are going to ping an email from a client across to the other side, you need your client's express authority, or better, in my view, to transmit to the other side in your own words the client's issues or the client's problems, provided you're not breaching confidentiality in any other way. I mentioned in the notes some issues with regard to the Conveyancing Protocol and also the Law Society's Conveyancing Handbook. And with regard to the Conveyancing Handbook, there's a number of points that I would like to make, if possible. Firstly, the first point really to explore is the idea that when we're dealing with a synchronized sale and purchase, the handbook confirms that what we should be doing always is completing our sale before purchase to allow the appropriate funds from sale to be used for purchase. So where we are exchanging contracts, where we are considering what to do in readiness to exchange, we of course always need to bear that in mind. And I think, again, when we talk about setting realistic client expectation, explain to the clients that on completion day there could well be problems with regard to the transmission of funds that mean timings with regard to the actual moving of house, leaving, vacating the property we're selling and moving to the new one may not necessarily be cast in stone. Again, important, after exchange, we'll explain to the client the position with regard to exchange of contracts, and the mechanics for completion need to be explained as well. The Law Society Conveyancing Handbook explains that in some detail. I mentioned in the notes the position with regard to the case of North Star Land and Maitland and Brooks, a 2006 case, which is an interesting case with regard to notices to complete. And again, in that case, there was sort of some dispute on the facts as to what clients weren't or weren't told about the mechanics of completion. I mentioned on slide here that if we are talking about the fact that completion may not take place and setting realistic client expectation, we should explain to clients having exchanged contracts in readiness for completion what the potential downside is where our client is in default with regard to their contractual obligations at completion. So again, this is something that's frequently overlooked, and when we're trying to condense the amount of information that we're providing to clients, this is an area where that condensation can create problem for us. What I would always suggest is that somewhere in our information that we're providing to clients, either in the report on title or post exchange of contract, readiness for completion. Look, Mr. Client, at completion, these are your duties and obligations. This is what will happen or could happen in the event of your default. So obviously we've got contractual interest as a potential problem. Remember that you can claim, if you're the innocent party, contractual interest or your actual loss. So again, it's important that clients keep records with regard to the loss that they've sustained where a breach of contract occurs and completion is delayed. You can't claim both, but you can claim one or the other, and it may well be that the actual contractual interest is dwarfed by the actual loss or damage that your client actually sustains. Remember that there are other equitable remedies such as specific performance, etc. But again, client, rather than going into detail about those remedies before a completion but after exchange, it's probably better not to tell the client about what can be done relating to other remedies until the problem at completion actually arises. But I think the idea of contractual interest or actual loss sustained being recoverable from the defaulting party should be explained to the client after exchange of contract. So part of my pre-completion procedure would be to provide the client with an information sheet about the completion process, and in that information sheet or in that link to our website, I would be providing clients with some background information relating to remedies for default, contractual interest or actual loss being the obvious things. I would leave other potential remedies and other potential problems until a problem arises. As I say that, I think when I spoke to you in the past about a conveyancing completion day nightmare webinar, I told you about a firm that sends out a sort of nightmare list of things that can go wrong at completion. I don't think we should be doing that necessarily, but I do think arming our client with appropriate information so that if a problem happens at completion, they're not all of a sudden surprised as to what can and can't be done is certainly going to be useful. The next point that I want to examine for a moment or two is when we're preparing really for exchange of contract, but thinking about it after exchange, where is completion going to take place? Well, the conditions of sale stipulate that the seller, in essence, takes control. The Conveyancing Protocol reiterates that position. But it might be appropriate to think, as we're exchanging contracts, whether an alternative could be appropriate. So what about ensuring completion takes place at the premises or at the offices of lenders, solicitors, or something of this nature? All of these things may be appropriate given circumstances. Now, a practical point, a realistic point. Are we really, as a buyer, going to be able to persuade a seller to move away from the norm and to arrange completion at an alternative venue? Highly unlikely. One of the things that we could do where we're concerned that a seller isn't going to provide vacant possession, where we have a situation where a seller is undertaking works to the property that are due to be finished at completion, is make time of the essence at exchange for completion. In those circumstances, if the seller defaults and doesn't provide us with vacant possession or hasn't completed the works that were contractually required to be completed, we can immediately bring proceedings for rescission or bring proceedings for other remedies rather than serving a notice to complete. So I think it's unrealistic in most circumstances to suggest to a seller that we're going to complete somewhere other than the seller's conveyancer's offices. But there might be circumstances where that is appropriate. Given that we are not being compliant with conveyancing protocol in those circumstances, that would be an issue I would flag up right at the very early stages of the transaction. If a problem arises during the transaction, it's something to be aware of. Generally speaking, once we've exchanged contracts, however, the place for completion will be cast in stone, and invariably that's going to be at the seller's conveyancer's offices. I've given you some detail in the notes touching on those issues, and it's just again something to be aware of with regard to some preparatory steps that should be taken in readiness for completion. Some golden rules to prepare for completion, again mentioned in the notes. Preparation, okay, so that we've got everything in good order, searches and search results back in a timely fashion so that we can deal with adverse entries. Making sure that we don't panic with regard to time constraints or lack of time. Making sure that we remember the golden rules about doing the simple things well, and making sure that we have time to do that. Frequently, when I see problems or negligence claims or client complaints in the conveyancing process, the conveyancer, you can see perfectly clearly what's happened. The conveyancer has either been forced into a corner by the client because of a lack of time, or because the client is putting pressure on the fee earner, the fee earner is not able to reject or oppose, or because there is an issue or problem and the issue or problem is not spotted, unusual but can happen, or again, commonly, there is a problem, there is an issue, but the client is putting pressure on the firm, the pressure has issues with regard to time, and the point there is, well, this isn't going to happen, this isn't really a risk, so let's just do the job and get it completed. All of those things create problems. So the idea of not panicking, sitting back and having a think is important. Talking to a colleague is important as well. Keeping clients in the loop is absolutely critical. Where we are preparing for completion and there is a problem, telling the client about what the problem is critical. But in addition to that, offering solutions. So, hey, Mr. Client, our search result isn't going to be back. We've got a problem or an issue with regard to an adverse entry. We've got a risk or some vulnerability with regard to the client providing, seller client providing vacant possession at completion. That's the problem. These are the things that we can do. Giving the client's choice, rather than to say to a client, that's the problem and this is the only solution. There may be other things that can be explored with the client. Now, again, I'm not saying that we've got to get the client in and we've got to give them a lecture on the concept of vacant possession or concept of breach of contract or what we're going to do with regard to an adverse entry in a search. Clearly, that is going to be impractical in a lot of cases, but just making sure the client understands what the problem is and making sure the client is aware of the choices that are available, I think is significant. Obtain instructions from the client, give advice, and then obtain instructions on that advice has to be the golden rule. So here I'm not talking about specifics relating to pre-completion processes. I'm talking about the client relationship and how we deal with clients to prevent problems arising, to ensure that clients can give us informed consent as to what to do, and so that clients can't argue or maintain that we haven't kept them in the loop with regard to communication. All of those things are very, very important. When I talk about communication, if I'm speaking to the client on the telephone about a problem, again, I would always confirm the conversation in writing. And as I've said to you on a number of occasions, if I'm having a difficult conversation with the client where there are fairly difficult problems that are all not particularly appetizing, making sure that I've got a note of the conversation, that I've got a note of what was said to the client and what the client said to me as to what the client wanted to do. The next point to emphasize, I think, this morning are some issues generally on undertakings and in connection with the form TA13, given what we've got with regard to some recent case law that we're going to look at in a moment or two. There's some general issues with regard to undertakings that I mentioned in the notes that I want to share with you. Point number one, be very careful about the provision of undertakings on the hoof. So, heat of battle, problem after exchange, we're completing on Friday, we need to get the job done, client is screaming, other side is screaming, we've got 20 or 30 other files that we need to work on as well. The easy thing is just to provide an undertaking to the other side that quietens things down and gets the job sorted. I would always ensure that my firm or I have as a conveyancer a series of precedent undertakings that have been prepared in the cold light of day that I'm happy with, that I'm comfortable with, that I've considered at length with colleagues. And I would always turn to one of those precedents rather than trying to draft something on the hoof, or probably worse still, accepting wording from the other side, because clearly the other side are going to want us to provide an undertaking that is comfortable for them, not necessarily comfortable for us. So the idea of having a precedent bank with regard to undertakings, I think, is very good practice indeed, and I would always be exceedingly cautious about providing anything other than a precedent form of undertaking that I've already got. Where I am providing an undertaking, ought to be in writing. If it's an oral undertaking, always ensure that you confirm it in writing, and be careful about anything that is vague or ambiguous. Make sure that we're being quite specific at all times with regard to any undertaking that we give, be it pre-completion, at completion, or any other point in the conveyancing process. In the notes, I have mentioned some case law relating to undertakings, namely the case of Patel and Daybell, which is in the notes there, in the 2001 case. And this is an interesting case because what the Court of Appeal said, going back all those years, is this: that you can accept an undertaking to discharge a mortgage at completion, and you wouldn't be negligent in doing so where that undertaking isn't honoured and where the client sustains loss, unless there were exceptional circumstances. So in the notes, I've mentioned what the Court of Appeal was considering with regard to exceptional circumstances. The two situations which were explored by the court, particularly with regard to expert evidence, was where an amount required to redeem a seller's mortgage exceeded the minimum level of indemnity insurance that the firm was carrying, or where the mortgagee was not a member of the Council of Mortgage Lenders, time back in 2001. So in those circumstances, we've already got a Court of Appeal decision advising us that these situations have the potential to be exceptional circumstances where a solicitor could be negligent with regard to accepting an undertaking. I'm going to show you a little later in my presentation what recent case law has done with regard to that position. The simple point with regard to undertakings, if you're acting for a buyer, is to first of all consider the wording that the seller is producing. Is the seller really going to be able to comply with that undertaking? It's all well and good accepting an undertaking at face value and thinking, well, if the other side can't comply with it, I've got a remedy. Yes, you may well have a remedy, but that remedy may require litigation, may require delays, etc., that could cause all sorts of problems for you and the client. So I think it's always worth looking at an undertaking and saying, well, do you think the seller is really going to be able to comply with this? And secondly, I think with regard to undertakings, and we'll develop this a little later, making sure that clients are aware as to how undertakings fit in the conveyancing process, being aware that there are circumstances where an undertaking could be breached and where the significance of that breach, where the extent of the significance of that breach and how it will impact on the buyer, I think, again, need to be explained to the client. Once again, I'm conscious of the fact that we're going to produce for the client a report on title pre-exchange. We're going to be providing the client with more information post-exchange in readiness for completion. Am I really suggesting that we send the client an essay, in essence, on the requirements for the sellers to provide an undertaking at completion and what happens in the event of breach of that undertaking? No, I'm not saying that. But I am saying that we should be explaining to clients in very sort of short wording, very concise wording, the fact that undertakings will be given by the seller's conveyancer, the significance of those undertakings, and a brief line about the fact that there is a risk that those undertakings can be breached. More on that later on, as I say, when we look at some recent case law. I mentioned the notes, issued with regard to best and reasonable endeavours. Again, this could be a situation where a buyer's solicitor is giving undertakings or a seller's with regard to vacant possession or the provision of vacant possession between exchange and completion, or a seller's conveyancer is giving undertakings relating to the provision of documentation. Again, it's important to understand the distinction between reasonable endeavours and best endeavours. And there's some case law on this that I was exploring over the weekend. Reasonable endeavours, reasonable steps taken by the solicitor provider or conveyancer providing the undertaking to achieve the outcome. Best endeavours, all steps that a prudent and determined person acting in their own interests and desiring the result would take. So a idea of best endeavours is significantly greater than the offering of reasonable endeavours. I would always suggest that where you're giving an undertaking to provide reasonable endeavours, you stipulate what those reasonable endeavours will be. And again, where you're suggesting best endeavours, given the fact that there is a degree of sort of slack with regard to interpretation, specifying what best endeavours in the particular circumstances where the undertaking is being given actually means. The next thing I want to talk about are some issues relating to the preparation of transfers in the conveyancing process. And there are a number of issues to think about, but I want to take and dissect a couple of them if I can. First of all, the issue of co-ownership in drafting the transfer. Is it important in the transfer to specify how the beneficial interest is to be held? Answer, yes. I'm going to show you quite a raft of case law where the courts have examined issues relating to circumstances where the transfer isn't clear as to how the beneficial interest is held, or the conveyancer or solicitor drafting the transfer hasn't thought about the issue at all and the position has been left blank in the transfer, or the transfer has been incorrectly completed. So we need to look at that. And the golden rule here is that where you're dealing with co-ownership, it is necessary for the buyers to sign the transfer, to acknowledge what the transfer says with regard to the beneficial interest. And it's also important to exercise care with regard to drafting the transfer to make sure that the parties' intentions relating to the beneficial interest and legal estate are clearly recorded. In the notes, I mentioned the use of Land Registry Form JO, which can be used, but I always maintain that it is used to support the content of the transfer and is not necessarily going to ensure that if the transfer is defectively prepared or doesn't deal with beneficial interest, the Form JO is going to get us out of difficulty if we're acting for a buyer. Form JO may reveal what the buyers intend with regard to legal estate and beneficial interest, but isn't a suitable replacement for a properly drafted transfer. Just as Form JO is not a suitable and appropriate replacement for a deed of trust where we're creating a tenancy in common. The next thing that I want to explore is some case law. And again, I've referred this in the notes, the case of Huntingford and Hobbs. And that's an old case, 1992, property purchased in joint names, transfer didn't contain any declaration of trust. In those circumstances, the court held a resulting trust arose. There was a presumption that the property would be held on a resulting trust in the proportions which they contributed towards the purchase price. The case, Huntingford against Hobbs, followed Dyer and Dyer and Pettit and Pettit. Again, I've seen situations where an error has been made with regard to transfer, or the transfer has been defective and has omitted to deal with the issue of beneficial interest, and Huntingford against Hobbs has been relied upon. The important point here is that there is a presumption in connection with the resulting trust, and a presumption that the joint owners hold the property in the proportions which their contributions evidence, but that can be rebutted. So if there is evidence of common intent in connection with the parties executing the transfer, that the beneficial interest would be held in different proportions, then the court will give effect to that intent. Again, in the notes, Gissing and Gissing, the famous case, Bernard and Josephs, Walker and Hall, more recent cases supporting that point. Other cases that I've given you in the notes concern sort of Crispin Mullins, Coucher and Coucher, sort of matrimonial cases generally, where in essence the courts are saying we're going to look at contributions that are made with regard to acquisition and also intentions relating to mortgage payments. In short, what we're looking for is making sure that when we're drafting a transfer and dealing with co-ownership, legal estate and beneficial interest are clearly identifiable and the intention of the parties, the intended co-owners, are given effect within the transfer. So I've given you details with regard to all of that in the notes and looked at some of the case law that flows from it, culminating in the case of Ralph and Ralph 2021. I don't know if you've seen this case, but in essence what you had here was a case where again there was a defective transfer and application made to the court to try and rectify the document. The error in the document was a manuscript cross in the transfer stating that the transferees hold the property on trust for themselves as tenants in common in equal shares. Matter went to trial. Neither transferees had ever intended that they should be joint owners in equity. There was a number of reasons why that wouldn't be the case. The position was that the court determined that the property was held for father alone, but as far as the beneficial interest was concerned, the position was that the transfer was quite clear as to how the beneficial interest would be held. The High Court said the transferees hadn't discussed how the property should be held, so there was no common intent or expression of any accord either within the transfer or elsewhere. It followed that it wasn't appropriate to vary the declaration of TR1 to say the property was held on trust for father alone, because that was never ever agreed. The court then had a look at this situation and said that it might be appropriate to rectify the TR1 by deleting the manuscript cross from the box on the form, but in doing so, that would leave no declaration of trust at all evident within the transfer. So the High Court came to a different view to the Court of First Instance, but in doing so, didn't really assist the parties with regard to the dilemma that the parties were facing. So the case went slipping off to the Court of Appeal. Different approach adopted by the Court of Appeal. The Court of Appeal basically saying, a standard point here, that the courts can't sort of reinvent contracts, can't imply terms, can't give effect to the intention of the parties where there isn't any intention. So the point was quite an interesting point within the Court of Appeal. And as I say, the important issue is that if a court can't find an agreement or intention within a document or elsewhere, a document can't be rectified. And the case highlights that we need to be careful when drafting the transfer. Again, this was a sort of father and son dispute. The position becomes even more difficult where we're dealing with non-social or domestic arrangements, where we're acting for people that are buying properties as investments, as commercial transactions. Absolutely essential that we get instructions from our clients with regard to what their intentions and wishes are with regard to legal estate and beneficial interest, and that the transfer mirrors our instructions. Remember, I've talked to you in the past about the use of co-ownership questionnaires. Here was a prime example where a co-ownership questionnaire would have prevented the Court of First Instance, the High Court and the Court of Appeal from attempting to undertake a number of different exercises to try and do justice between the parties. Ultimately, justice couldn't be done between the parties because it was impossible to determine what the parties actually intended. In those circumstances, the court was reluctant to modify, correct or amend the transfer, which was clearly defective. The next thing I want to talk about with regard to transfers is an area that causes negligence claims on a fairly frequent basis, dealing with sales of part. Absolutely essential when dealing with the transfer of part that we describe the extent of the title carefully, with reference to national grid coordinates, stakes, or physical features. On the issue of stakes, I've just been reading a case that went to a first-tier tribunal involving a determined boundary application to the land registry. And the location of the boundary was impossible to ascertain because the property had been described as being delineated or defined by reference to white stakes that had been put in the ground. But the chartered land surveyors that had been instructed by the parties to produce a report to try and confirm where the actual boundary sat couldn't agree which part of the stake formed the boundary. So what you had was a stake, a piece of wood, that was about 4 centimeters square. And one of the experts was arguing that the boundary was, in fact, the south face of the stakes, and the other side was saying it was the north face of the stakes, and the distinction between the two was a distance of approximately 4 centimeters. Just shows you how ridiculous boundary disputes can be, and shows you once again the problems with boundary identification. The chair of the tribunal emphasizing that if you're going to use stakes in this context, you should specify in the description of the title which face of the stake is the boundary to the property, so that we're getting closer and closer to that pencil line delineating my boundary from yours. If we're producing a plan in connection with a transfer, it must be Practice Guide 40 compliant. The physical description of the property in the transfer and the plan must be consistent with one another. Remember, when we first sort of started doing these presentations, I talked to you about a case where you had a transfer and a plan. The transfer referred to the fact the property was more particularly delineated or defined by reference to the plan, but on the face of the plan, it stated it was for identification purposes only. And I've also referred you in the past to another case where the contract referred to the fact that if there was a dispute, the description of the property as per the plan prevailed over the description within the contract. And the court said, well, that was irrelevant. The issue was looking at the site, which made the most sense, the description or the plan. And the fact that the description said the plan prevailed was irrelevant. So be careful with that. Make sure you're getting professionally prepared plans. Make sure you're describing the property as carefully as possible. The issue of restrictive covenants, important point here. Given the planning regime and relaxation of planning, etc., restrictive covenants are becoming more and more significant, and the utilisation of restrictive covenants to prevent, preclude, or manage or control development even more significant. So we should be thinking and asking clients where we're selling part, do we want to impose restrictive covenants? If we do, then of course the transfer should make sure that the restrictive covenant is clearly worded, that emphasis is placed with regard to how the restrictive covenant is to be protected, and emphasis placed as to who can enforce the covenant and against whom the covenant can be enforced to. And the granting of reservation of easements, critical. Again, the transfer should be carefully drafted so that easements are enforceable. And again, I was just looking at some recent case law over last weekend and over the bank holiday there. And every week you see a whole sort of list of cases where problems arise relating to easements, particularly rights of way. And the problem is, one, the physical extent of the way, two, the description of the legal extent of the way, and issues of enforceability. So again, the contract will deal with all of these issues, but when we're drafting a transfer on behalf of a buyer, it's important just to check that what we've got is going to be an enforceable easement, or is going to be an easement that's capable of being enforced against us. Moving on, if possible. The significance of Ralph and Ralph, as I say, it applies to domestic situations. The position with regard to commercial contracts, Ralph and Ralph doesn't help us with. And again, I've mentioned in the notes some detail here that where we are dealing with a commercial residential transaction, a buy-to-let or an investment acquisition amongst not strangers, but not people that are socially or domestically connected, we need to be very careful about how we draft the transfer so that the issue of co-ownership is quite clear. Next thing I want to talk about are some issues with regard to searches. And the first thing that I mentioned in the notes is the need, after exchange of contract, to undertake an exercise to see if pre-exchange searches need to be renewed on the basis that they're out of date, on the basis that we've got information from the seller, from our client, from our surveyor or valuer, that means that the local search or other pre-exchange search is now out of date. And I think, Robert, the first thing to say here is that you've got some products that neatly fit the bill, where I've got a search, particularly a sort of local search, that is out of date, or where I'm worried that there's going to be a delay between exchange and completion, meaning the search could become out of date. Robert, could you just explain what products you've got that would assist the conveyancer in those circumstances? Hello, Robert.
Hello, sorry about that, Ian. Just had a bit of trouble connecting with you. Yes, we do. I mean, in the normal situation where you have well, as you know, all searches are out of date the minute you get them. So there is an argument for always updating them, really. But we do have search validation policy, which can be used, and I think are probably advisable where there's been any substantial delay since you got the initial search, or if you've been sold the benefit of an old search, certainly, then it's worthwhile doing there, and they can be obtained quickly and easily, and premiums start there from about £10 for a property. So it's quick and easy to do there. The situation there where you mentioned if you received any further information, obviously that would need to be disclosed, or would certainly affect the validity of any policy you get there if you are aware of a problem before you get the policy.
Yeah, thanks for that, Robert. Yeah, of course, there is the issue of disclosure of any material facts that you need to take into account. But the fact there is a product there is helpful. Just as an aside, local land charges searches, where the local land charge search has migrated to the land registry do allow you, where you've sought an official search, to update the search for a period of 6 months from the date of search. Just be aware of that. But certainly, as Robert mentions, where there is an issue with regard to a search being out of date, where you're concerned about protecting your client and indeed your firm, the Stewart title have a product that sits very comfortably with that issue and enables you to protect the client. And as I say, with a lot of these policies, it's not just a question of protecting the client, it's a question of protecting your firm as well. I think we've had this discussion, haven't we, before, Robert, where, you know, frequently the idea of an indemnity policy enables us to drive the deal forward, get the deal done and keep the client happy. At the same time, it also affords us protection in circumstances where, you know, the client contends at a later date that we have been negligent.
Yeah, I think that's certainly the case here, and you can use it there. And I mean, it gives protection to all the parties there, the lender and the buyer as well. So it's certainly worthwhile considering.
Yeah, great. And Robert, last question on this point: can I buy the product online? I can just deal with it rather than having to speak to an underwriter, etc. It's just a policy that's available.
Exactly, any policy like this can be done online and on Stewart Solution, even for dinosaurs like you and me, Ian. It's a 90-second process to get the policy issued out to you.
Fantastic, thanks for that. Yeah, I concede I am a dinosaur as well. Yeah, I was talking to someone earlier this week about something, and we might well have been talking Martian because we were so into some software issues, but that's a different story. But registry searches, very quickly, priority periods. I've mentioned in the notes some issues with regard to priority. Looking at Rule 15 of the Land Registration Rules 2003. And the important point here is that the priority begins at the earlier of, the time of day notice of it is entered in the day list, or midnight marking the end of the day it was received if the application was received before 12 noon, or midnight marking the end of the next business day after the date was received if the application was received at or after 12 noon. Again, important to understand that, and also important to understand when priority ends. Midnight on the 30th working day, but if you look at the Land Registry guidance, that in essence means noon on the 30th working day. Number of points here that are worthy of exploration. Firstly, the concept of a working day is different to a business day. So again, it's important to understand that a Land Registry working day wouldn't necessarily be an ordinary business day. And again, important to understand the potential dangers with regard to undertaking land registry searches to extend the priority period as much as is possible beyond the day of completion. Again, I know practitioners over the years that have undertaken land registry searches, so the search result comes in on the morning of completion, or the search is undertaken on the morning of completion to maximize priority period. And that's fine, assuming that the search is viewed as a simple academic exercise and we're not going to get any adverse entries, so we've got nothing to worry about. And yeah, okay, fair comment. In the vast majority of cases, we're not going to have anything to worry about. But I have seen problems where search comes in on the morning of completion, adverse entry, seller has no opportunity whatsoever to try and remedy the position to allow completion to take place. So either you've got a delayed completion with people scurrying about trying to get the issue resolved, or going back to what I was saying a little earlier about the provision of undertakings being given so that the buyer can move in on a temporary basis by way of license, pending getting everything sorted out. So a question I'm often asked is, well, what would be a safe thing to do? Well, my view is that at the very least, we should be giving ourselves 3 working days before completion to deal with adverse entries. And therefore, I want search results in, at the very worst, 3 working days before completion, ideally a week beforehand. But even that may not be sufficient. Again, important to understand, and for the client to understand, what a land registry search does and doesn't do. And here's an important point. Again, going back to this idea about informed consent and explaining to the client the conveyancing process. Frequently, when I'm looking at firm standard letters and information they produce relating to the conveyancing process, clients are not made aware of the significance of a land registry search and not aware of the significance of the priority period that a search generates. So again, it's something I think that clients should be made aware of on the basis that they understand and appreciate just how difficult our task is and how much pressure we are under with regard to preparing for completion, and then post-completion issues. Often I think that because we don't educate clients, we sort of create a rod for our own back, in that clients think the conveyancing process is easy, that we get our money for nothing, and they don't understand where, again, something goes wrong in the process. So we've got to achieve this balance of not bombarding clients with communication, documentation, and information, but at the same time making sure that they have sufficient information to understand the conveyancing process and our role within it. I've given you a lot of information about searches and about land registry practice. I'm not going to dwell too much on that. I want to talk about execution of documents. And again, the issue concerning electronic signatures. A lot of detail in the notes here about the fact that we can have transfers executed electronically by our clients. When we're drafting the transfer, it is important that we take into account that this might be necessary and appropriate. When drafting a transfer that's going to be signed electronically, it is important that we add a statement to the document for our witnesses, asking them to confirm that they were physically present when the signatory signed the deeds. it is important to understand that as far as that process is concerned, the Land Registry might requisition you where a document has been signed electronically to determine just how the witness signed the document and what the witness saw and what the witness witnessed with regard to the electronic signature by the buyer or by the seller. In the notes, I mention a sort of checklist that we can use with regard to execution of documents. The first thing I would say is that really it's the buyer's responsibility to take the lead, or the buyer's conveyancer's responsibility to take the lead with regard to the use of electronic signatures. So it's important after exchange, if it's possible, pre-exchange it may be necessary to determine whether documents are going to be signed electronically by seller or buyer. Where seller or buyer are both signing electronically, then the same platform should ideally be used. Where that isn't the case, then the use of a counterpart transfer seems to be an acceptable way of proceeding. Just as where you have one party that's signing a transfer electronically and another one is utilizing a wet signature, then again a counterpart transfer would be appropriate. It is important that if you are allowing clients to sign documents electronically, that you've got a completion certificate or audit report that's produced by the platform that you're using that generates an audit trail with regard to the method of execution. Again, the Land Registry might ask to see this if there's any sort of concern about the electronic execution process. I have mentioned in the notes a number of other points that I think are relevant. The important thing to understand and to appreciate is that we have to, as conveyancers, manage the electronic execution of transfers. With regard to the use of digital mortgages and electronic execution of digital mortgages as part of the remortgage process, you will recall when we discussed this, that frequently our role is very limited and our vulnerability and exposure exceedingly limited as a consequence. With regard to electronic signatures of transfer documents, the position is not the case. And again, in the notes, I've explained the process that should be utilized in some detail. Again, I don't have time to go through it today, but the important thing is to have a look at the process and understand. Buyer's conveyancer takes the lead because the buyer will be submitting the electronically executed document to the Land Registry. But where all parties are signing electronically, the buyer's conveyancer should select the electronic platform that's going to be used. Where we've got two different platforms, we use counterpart transfers, where we've got electronic signature and wet signature being utilized by the parties, again a counterpart transfer process adopted, and there is an 8-step mechanism that is utilized and recommended by the Land Registry, which I've given you in the notes for your consideration. Going back to sort of executing documents generally, I mentioned in the notes the use of signatures and problems that the Land Registry have encountered in the past relating to signatures, and the recommendations from the Land Registry where we've got people signing in using foreign characters by way of signature, where people are unable to sign, where there are problems with regard to disabilities. There's Land Registry guidance with regard to all of that. There's also Land Registry guidance about who may witness signatures. Another point here to mention really is that a party to a deed can't witness the signature of another party. It's called Seal Against Claridge, 1881, authority for the point. I had an email from someone on Saturday about this point and about whether or not the witnessing was a valid witnessing, and unfortunately I had to advise, courtesy of this case, that that wasn't the case. Signatory spouse, civil partner or cohabitee can act as a witness theoretically, but it should be avoided. And of course, witnesses should not be younger than 18 in order for the execution to be valid and enforceable. I have mentioned in the notes some issues with regard to delivery of the document. And again, all the Land Registry are really interested in is that there is no evidence to confirm that there has been a problem with regard to delivery of the transfer as a deed. There is a conclusive presumption in favour of a buyer that the conveyancer is authorised to deliver it, and the Land Registry will assume that a deed has been delivered as a deed unless there's something indicating anything to the contrary, which is highly unlikely. I have mentioned already the need for attestation to be carefully considered where electronic signatures are used. Moving on, if I may, I have at item 6 of the notes gone into a little more detail concerning undertakings, courtesy of this case of Harcus Sinclair and your lawyers. I've explained what an undertaking is, and I've explained that in a conveyancing context, the undertakings provided by a seller in TA 13 and at completion are hardly likely to be anything other than undertakings. It is important to understand that where an undertaking is given, if you have instructions from your client to do something contrary to that undertaking, your obligation relating to the undertaking prevails over your obligations to the client. Again, it is important that clients understand, if you're acting for a seller, what the undertakings that you give at completion are and their significance. I mentioned in the notes quite a bit of case law, which you can have a look at relating to undertakings. The important point really is that when you're drafting an undertaking, you are concise and precise relating to wording. If an undertaking is vague or ambiguous, it will be construed against the person that has drafted it. I have mentioned in the notes this case of Harcus Sinclair against your lawyers. Number of things to discuss this just before we sort of move on to the last part of my presentation. Firstly, Harcus Sinclair doesn't do anything new. It doesn't get everyone terribly excited and everyone sort of jumping up and down and changing systems and processes. It shouldn't do that, because what the Supreme Court has said and what the Court of Appeal and High Court have said relating to undertakings is nothing new. The important thing to be aware of is that really, because of what the Supreme Court has said obiter, practitioners need to be aware of a number of things. One, in an ideal world, if we're being ultra cautious, we should advise clients about the potential dangers of a seller's conveyancer breaching an undertaking and the implications of that as far as the conveyancing process. Secondly, again, being ultra cautious, we should only ever accept an undertaking that's provided from an individual solicitor within the firm acting for the other side. And the reason for that is that the Supreme Court has emphasised that an undertaking from a solicitor carries an opportunity for enforcement, as that solicitor is an officer of the court. The case highlights the fact that we need to be careful about undertakings that are provided by the entity on whose behalf the undertaking is given, the firm of lawyers, the firm of licensed conveyancers. The Supreme Court emphasised that incorporated legal practices authorised to provide legal services are not officers of the court in the same way that a solicitor is. In those circumstances, the remedies that are available for breach of undertaking are not as extensive. That's the cautious approach, courtesy of the decision. The sort of pragmatic alternative approach is, I think, in order to mitigate risk and vulnerability, to tell clients about the problems with undertakings, to check the level of indemnity cover that a firm that is giving an undertaking is carrying, to make sure that the amount that's being required to redeem the mortgage is less than the indemnity cover that the firm is carrying. Perhaps requiring confirmation that redemption monies have been sent and asking for proof of receipt or acknowledgement from lenders. I mentioned in the notes that we should watch out for undertakings in connection with removal of notices on registered titles. Again, because I've seen undertakings that have been given that are incapable of being complied with. So, when giving undertakings, again, I mentioned in the notes, specify the corporate entity on whose behalf the undertaking is given. Be careful about the wording of the undertaking and be aware that if you are a solicitor, the undertaking that is being given is an undertaking given by you as an officer of the court, meaning potential sanctions against you as an individual, as well as sanctions that are available relating to the breach of undertaking generally. So just to reiterate, Harker Sinclair doesn't change the ball game at all. We're still waiting for Law Society guidance, although there was an article in the Law Society Gazette, I think it was last week, dealing with this particular point, but basically just confirming the points that I've made to you in this presentation. In short, making sure clients are aware of what an undertaking is and the potential dangers of breach of undertaking, and limiting risk and limiting vulnerability with regard to undertakings that are provided. Really going back to the case law that we looked earlier on in my presentation, the 2001 case that we looked at and discussed. I mentioned finally with regard to undertakings, TA 13, section 5, and section 532, section 53 and 32. All of these replies amounting to solicitors' undertakings. So all that I've said relating to undertakings given at completion apply to undertakings that are generated courtesy of replies to questions in form TA 13. Practical issues to finish today before we start looking at some questions. When we're preparing for completion, always check outstanding issues. Do that before exchange and do it as we are preparing for completion. Those of you that have software or case management systems, you should have an issues page in that system for each transaction. Things that are outstanding that need to be reviewed before important steps are taken in the transaction. If you are using a file, a sort of paper file, I would have an issues page on the front cover of the file, inside front cover of the file, or on the file in a different colored paper that I can look at and just check before I'm committing to exchange or committing to complete or in readiness for completion. The issue of informed consent is important. Again, over the holidays, I was looking at a professional indemnities insurers' reports, and what they were saying is there are more and more negligence claims arising from a failure to correctly transmit information to the client to enable the client to decide what ought to be done or not to be done with regard to the transaction. Preparing of completion statements, be careful. Provide clients with the source documentation that you're using for the completion statement, estate agents' accounts or invoices, and ask the client to sign them to approve them. Redemption figures, again, provide the clients with the basic information upon which the completion statement is utilized. With searches, think about what happens if there's a problem. With regard to execution of documents, these days we've now got the use of electronic signatures. All right, not commonplace, but it's out there and it's going to become more and more commonplace in my view. And in preparing for completion, just as in the life of the conveyancing transaction, beware of property fraud. Remember Dreamvar Properties and Currency? Those cases before lockdown with regard to seller identity fraud, and the court's emphasizing that we should be checking client signatures on documents throughout the transaction. Well, the transfer document the mortgage deed, anything else that is signed by the client needs to be checked just to make sure it's consistent with other signatures. Stephen, I'm conscious that I've overrun time, but hopefully we do have a little bit of time for questions. While I'm just waiting for Stephen, be aware that Robert is available for sort of information concerning products that Stewart Title are able to offer, in particular the product that we explored a little earlier relating to delayed searches. Sorry, Stephen, question time.
Yeah, no problem. Thanks, Ian. Yeah, we have had a few questions in. The first question is, would increased Sdlt liability arising because of seller delay be recoverable? That was from Mark.
Yeah, it's a great question, and the answer is no. But what you could do is put a special condition in the contract if that was going to be an issue. But yeah, that wouldn't be loss, that would be recoverable. Because what you're talking about, what I was talking about was damages, actual loss flowing from breach of contract. The breach of contract arises when completion is agreed, contracts are exchanged, and seller is in breach of contract. The fact that the seller has, for whatever reason, caused delays that have meant completion has not taken place when the buyer required for Sdlt purposes, that wouldn't be sufficient to enable additional Sdlt liability to be recoverable, Stephen. Great question, Mark. Thanks for that.
Okay, yeah, thank you. Thanks, Mark. Next question is from Brian. Brian asks, many sale contracts have a special condition that the recipient of a notice to complete will pay the giver of the notice £150 plus VAT where the completion has been delayed beyond the contractual time of, say, 2 p.m. If the buyer is late, the sellers then refuse to complete unless the £180 notice fee is paid. Is it too late to argue the special condition accepted on exchange is unenforceable because it may be illegal or a penalty which cannot be demanded?
Yeah, well, Brian's right. I would always argue that point. The fact that it is being agreed in a contract wouldn't preclude it from being a penalty and your ability, therefore, to challenge it as void. So Brian's quite right. It's a clause that's commonly encountered, but potentially unenforceable if litigated. I haven't seen it litigated because invariably, you're not going to litigate about £150 payment. Sure. I have seen, if Brian drops me a note, and perhaps it's something I'll have a look at next time, I have seen a case, but I think it was unreported, where someone refused to complete because the £150 wasn't paid. And I think the court said that you weren't allowed to refuse to complete, but that the debt could be pursued as a sort of debt action, but that wouldn't preclude the seller from being compelled to complete on the basis that the purchase price was made available by the defaulting buyer. So just to explain that, as I say, I'll have to dig it out, but I think I've seen an unreported case where the court said the £150 fee that is due, that could be pursued by the seller in a county court action as a debt claim. You can't use that being outstanding as grounds to refuse to complete.
Okay, yeah.
Does that make sense?
Yeah, absolutely. No, thank you, Ian. Thank you. And yeah, thanks, Brian, for that question. A question for Maria, which kind of touches on insurance, but I think it can be answered either way, if there is an answer, of course. And that's with regard to search validation policies. What if the lender does not accept search indemnity policies? I think I know what the answer to this may be, but
yeah, well, my view is if that's what the lender's stance is, then at the end of the day, if the search is undertaken on behalf of the lender, you've got to comply with the instructions that the lender sends you. Stephen, what would you say?
I'd agree. I think that's right. It's really what the lender says, and unless you, if you want to work with that lender, you have to comply with that. You're correct. Yeah.
I'd suggest, Stephen, the answer here is, as it always is with lenders, they've got the money and you haven't. So really, they do call the tune on these things. But in the specific case that Ian was talking about there, you might be doing that search purely for your own comfort and your client's comfort. Lenders are normally happy with a search which is up to at least sort of 4 weeks, if not 8 weeks old at the date of completion. And I don't think there's been many cases of lenders bringing action against a solicitor who's completed on the strength of a search of that age. So this actually might be in addition to the normal protection for the lender, so it might still be worthwhile doing.
Yeah, that's a good point, Robert. Yeah.
Absolutely. I'll just do one more question, Ian, and then we'll just focus on the poll before wrapping up.
Yeah.
So Mayumi asks, well, so she says, could you also recap on the parties' responsibilities on the property condition? On post-completion, the buyer solicitors claim that the property is damaged, stroke in need of repair, but my understanding is that the seller's duty does not extend to matters arising before the date of the contract.
Yeah, great question. The position is as follows, that the buyer is deemed to take the property in the state and condition it is in at exchange of contract. Okay, so if there is a material change in condition between exchange and completion, that potentially would allow the buyer to rescind. But the problem there is, and the point that I frequently raise to practitioners, how do you know if you're a buyer what the state and condition of the property is at exchange of contract unless you've inspected it? Which is why I always say to practitioners, if you're ever acting for a client who's buying an empty property or a property that's in an area that's prone to vandalism or damage, it's worth someone, ideally the buyer, inspecting it at the point of exchange to identify state and condition. But only if the state and condition materially alters between exchange and completion would a buyer be entitled to rescind the contract. But the buyer would be so entitled. Would be entitled to claim his deposit back and refuse to complete. That's assuming that you've got evidence of state and condition at exchange.
Yeah. Excellent. Okay. Thank you, Ian. Thanks, Mayumi, for that question. Just before we wrap up, I'll just share the results of the poll. As always, very interesting. Not one score left untouched, so a bit of a mixed bag, but I'm going to be the optimist and say that there are more saying 3, 4 or 5, so stable to booming for the next 6 to 12 months. Ian, did you want to come in on that at all?
Yeah, I think I was talking to someone yesterday about this, and you know, again, what I'm saying, my heart says uncertainty. My heart says lots of, depending on locality, lots of properties being built. My heart says a boom time to sort of put a property on the market. So it's, you know, we've got to be optimistic and say from a conveyancer's perspective, there's going to be plenty of work out there. My head says that at some stage, it's got to steady down again. You know, we can't just keep going the way we have been going with the market so vibrant. So heart says, yeah, great, happy days. You know, it's going to continue and things are good. Head says, you know, it can't. There's got to be some form of constraint. There's got to be some form of limitation. We've got to get back to some form of normality, because I don't think the market currently is normal. What do you think, Stephen and Robert?
Yeah, well, I'm inclined to agree. I think this isn't a normal market. It's been very inflated for a while. What I do find interesting with the feedback on the poll is that if you read any given article on any given day, it just shows how hard it is to predict the future of this current housing market, because there's an article that probably depicts every single score on that chart saying, well, actually we're coming into a very uncertain period now, versus no, this boom will continue, and there's a lot of reason to be optimistic. So it depends what article you open up on what day, I think. But Robert, any thoughts on that?
Yes, I mean, I tend to agree with you on that. I think we're still in an unusual market. As people get back to the office, get back to their places of work, some of the spare cash that's been released by working from home will go. I think then we must get back to a situation more like the market was in early 2020, possibly, made worse by increased prices, perhaps a bit of clamping down on wage increases and so on. So I would see it like 2020, but on the pessimistic side of that, probably.
Yeah.
But that wasn't a bad market in 2020 at the start, so that's not a bad place to start at.
True. Yeah, good point. Good point.
Absolutely. Anyway, I think if you're okay, we'll wrap up there for the session.
Yeah, thank you. Thanks, everyone.
Excellent. So just to wrap up and say thank you to Ian and everyone for attending the session. If you do have any more questions, and there are a couple of questions we missed out there, we will respond to those. But if you do have any others, please contact Ian or myself. As you'll be familiar with by now, if you leave today's webinar, so when you leave today's webinar, you will receive an automated message from GoToWebinar. If you respond to this, the replies will come directly to myself, and I can pass on any questions or feedback to Ian. You will also receive a separate email from Robert, which will contain the slides and notes to today's session. That will be within the next 48 hours or so. So that just leaves me to say, on behalf of Stewart, Title, and Quayle, thank you for joining us today, and have a great rest of your day. Thanks, everyone. Goodbye.